Good morning, everybody. We take a report from Institute of Intellectual Property, 7 October 2021. And today we will discuss case law, which is called Spiegel Online GmbH. This one is granted by a German court. Very, very interesting. So the case very interesting. They will cover the problems of the copyright law. The request has been made in proceeding between Spiegel Online, which operated the internet news portal Spiegel Online, and Mr. Volker Beck, who was a member of Bundesgerichtshof at the time when the referring court decided to make a reference to the court concerning Spiegel Online publication on its website of a manuscript by Mr. Beck and an article published in a book. So it's very, very interesting to see the case and to see how it's going. So we have many regulations concerned to the EU law and in German law. So in the German law, paragraph 50 of the Gesetz über Recht und Privatschutzrecht, Law on Copyright Related Rights, 1965, provide for the purpose of reporting on current events by broadcasting or similar technical means in newspaper, periodical, and other printed matter or other data carrier mainly devoted to current events, as well as on film, the reproduction, distribution, and communication to the public of the work which become perceivable in the course of these events shall be permitted to the extent justified by the purpose of the report. So under heading quotation, paragraph 51 of the URGS read as follows. It shall be permissible to reproduce, distribute, and communicate to public or published work for the purpose of quotation, so far as such use is justified to the extent by the particular purpose. It's more permissible in particular where subsequent to publication individual work are included in an independent scientific work for the purpose of explaining the content. Subsequent to the publication passages from a work are quoted in an independent work. And thirdly, individual passages from releases musical work are quoted in an independent musical work. So dispute in a main proceeding and the question refer for preliminary rulings. So we have many things in a case. So we just focus on things. So for the first question, as a preliminary matter, it should be noted, as is clear from paragraph 14 above, that the first question related to the application by a referring court for the purpose of disposing of a case in the main proceeding of the rules on the reporting of current events in quotation, laid down respectively in paragraph 50 and 51, which transport Article 5 of Directive 21. In that context, the referring court asked whether that provision of EU law allowed the member state discretion on its transposition, since according to the case law of the Federal Constitutional Court, national legislation which transposes an EU directive must be measured as a rule, not again a fundamental right guaranteed by the basic law for the Federal Republic of Germany, but solely again a fundamental right guaranteed by EU law, where that directive does not allow the member state any discretion in its transposition. So we have many case law websites here. It's many. It's one of the special things of case law of the European that you have many things related to the things. Third question. And then we go to very essential things. Second question. The second question remains on the fundamental right. The fourth question, to use the quotation for the purpose of reporting on current event. Sixth question. So refer to the consent of author. And then we have conclusion. So it's better we go into scrutinize the conclusion and then we go back to the question and follow. So for conclusion, Article 5, second case of Directive 21 of the European Parliament of the Council of 22 May 2001 on the harmonization of certain aspects of copyright and related rights in the information society must be interpreted as not constituting measure of fully harmonization of the scope of the exception or limitation which they contain. Freedom of information and freedom of press enshrined in Article 11 to the Charter of Fundamental Rights of the European Union are not capable of justifying beyond the exception or limitation provided for Article 5 and 3 of the Directive 2001. A derogation from the author exclusive right of reproduction and of communication to the public, referring to in Article 2 and Article 3 of that directive, respectively. In striking a balance which is incumbent on the national court between exclusive right of the author referred to Article 2 and Article 3 of Directive 2001, on the other hand, and on order the right of the user of protected subject matter referred to Article 5, second case, and D of the directive, the latter of which derogates from the former, a national court must, having regard to all the circumstances of the case before it, rely on an interpretation of the provision which consistent with their wording and safeguarding their effectiveness fully adhere to the fundamental right enrichment of the Charter of Fundamental Rights of the European Union. And Article 5, second case, Directive 2001 must be interpreted as precluding a national rule restricting the application of the exception or limitation provided for that provision in cases where it is not reasonable possible to make a priority request for authorization with a view to the use of protected work for the purpose of reporting current events. And Article 5D of the directive must be interpreted as meaning that concept of quotation, referring to in that provision cover reference made by means of hyperlink to a file which can be downloaded independently. And Article 5 must be interpreted as meaning that a work had already been lawfully made available to the public, where that work in its specific form was previously made available to the public with the right holder authorization, or in accordance with a non-contractual license or statutory authorization. So in this case, we have learned that the concept of quotation, we said as cover a reference made by means of hyperlink to a file which can be downloaded independently. So the meaning of quotation. And then here, the set anything needs to ask for the permission of the right holder. So the right holder authorization is very important when we use copyrighted work. And then lastly, for the things for reporting some current event. So it's not reasonable to make a prior request for authorization with the view of user protected for the work or purpose current event. So in this case, very see that very complicated to understand. And the sixth question is very important. So we just go through, see how the court saying. By this question, the referring court asks, in essence, whether Article 5 of Directive 21 must be interpreted in the meaning that a work had already been lawfully made available to the public, where that work in its specific form was published previously with author consent. And it is clear from Article 5 Directive 2001, the exception for quotation apply only if the quotation in question related to work which had already been lawfully made available to public. So the exception of quotation apply to a work already being lawfully made available to public. It's very important. So in that regard, the court has previously held that expression mise à la disposition du public d'une œuvre, making a work available to the public in the French language version must be understood with the meaning of Article 5 of Directive 2001 and the meaning of act of making a work available to the public. That interpretation being supported both by expression made available to the public and there often list case you can list the match which are used indiscriminately in English and German language version of that article. So you can see the case panel 2011. And to whether work had been lawfully made available to the public, the court has pointed out that the only quotation permissible, provided that the other condition provided Article 5 Directive 2001 satisfied. A quotation from work which has already been lawfully made available to the public. First, it must be held as a work or part of work has already been lawfully made available to the public. If it has been made available to the public with the authorization of copyright holder in accordance with a non-contractual license or statutory authorization. So it's very important that the court explain how to justify a work can be available to public. So whether they have the authorization of copyright holder or they have something which is called non-contractual license or statutory authorization. So that means that the work needs to be accorded by the author in order to present to the public. So in the present case, the referring court asks whether Mr. Beck's work may be regarded as having already been lawfully made available to the public at the time of publication of his manuscript in 1980, at an article in the book, in the light of the fact that manuscripts were allegedly subject of minor change prior to publication by publisher of that book. It's asked whether Beck publication on his own website and the document accompanied by statement of dissociation constitute making its lawful available to the public. It must be borne in mind in that regard that it is for the national court to decide whether work has been lawful made available to the public in the light of a particular case before it and by taking into account all the circumstances of the case. So, in particular, it is for the reference court in the case of the main proceeding to ascertain whether at the time of Mr. Beck's initial publication of manuscript, at an article in the book, for publisher had a right, whether contractual or otherwise, to undertake the editorial amendment in question. If not, would need to be held that each option of right holder consent the work in form in which it was public in that book were not made available to public. So you see the court just said it were not been lawful available to the public, and it's just, you know, arguments just go around and around, very interesting cases. However, it is clear that Mr. Beck's manuscript and article were subsequently published by the copyright holder himself on his own website. The reference court state, however, that publication of those documents on Mr. Beck's website was accompanied by a statement of dissociation by him from the content of those documents across page level. Thus, at the time of publication, the same documents were lawfully made available to the public only in so far as they were accompanied by those statements of dissociation. So in any event, in light of the consideration already set out in paragraph 83 above, for the purpose of the application Article 5 and directive, this is for reference court to ascertain whether the original version of manuscript and the article published in the book in question, without Mr. Beck's statement of dissociation from the content of those documents, were published in accordance with fair practice and to the extent required by the specific purpose of quotation in question. In light of foregoing consideration, the answer of this question in Article 5 must be interpreted as meaning that a work focusing. A work has already been lawfully made available to public, where that work in its specific form were previously made available to public with the right holder authorization, or in accordance with a non-contractual license or statutory authorization. So that means the court they didn't consider the works already were made available to the public. All right. So that's the case. So if you have any question, please don't hesitate to pose a question. It's very interesting to see the case. So you can see the case of here, the first remark. We can see that the degree of freedom member state in relation to copyright exception and fundamental right as external limit to copyright protection. And lastly, the reinforcement position, copyright exception and limitation at user right. So why the CJEU reject the opportunity to justify further limitation of copyright on the basis of freedom of expression? It is, however, affirmed that exception and limitation of Article 5, Article Info Sub-Directive shall be adequately safeguarded because they confer right on the user of the work. So in this case, The recognition of certain exceptions as right of lawful user were inconsistent and only in relation to computer program database and some other things. So very, very difficult for us to see how it's going in this case. So you see, together with a judgment in Funk Median in Panham by the Grand Chamber of Court Justice of the European Union. This referral answer from Germany focused on quotation exception in the InfoSoc directive and the compatibility with EU law of an open the general copyright exception like German free use. In his opinion, Black on January, the CJEU ruled that quotation within Article 5.3d of the InfoSoc directives require one to consider the purpose of quotation at issue, and fundamental rights like freedom of expression do not allow EU member states to go beyond the Caselaw exception of Article 5. They envisage new exception or even introduce a general fair use clause. So for that matter, in my view, that's where once again a correct assessment and thoughtful analysis for right. And in today's decision, the test of which not yet available to the public, that the CJEU ruled that the use of protected work for the purposes of reporting current event does not, in principle, require a prior request for authorization. So that's the problems of quotation limitation in this case. And sometimes not easy to understand the case. So we just go back to the article and see how it's going. So the CJEU rule on the scope of the quotation limitation to copyright infringement and the application of fundamental freedom. CJEU released its judgment in 3 copyright cases. So Spiegel online, as we have seen, and then we have other cases like Panham and Funk Median. So this case concerns an article published by Spiegel online regarding an article by a German politician, Volker Beck, that were originally published in a book in the 1980. German court refers 6 questions to CJEU. The majority of the judgment appear to be revision of familiar and well-rehearsed principle of construction of EU law with repeated circular references back to the wording of relevant directive. However, there are some particular comments of interest on the interpretation of the exception to copyright infringement for the purposes of reporting current event and quotation more generally. So, one of the reasons this case may have received particular attention is due to the subject matter of particular fact. Volker Beck was an author of a manuscript that was published in 1980 under personal name as part of a book. This manuscript related to criminal policy in sexual offenses committed against a minor, and it appeared that some controversial comments were attributed to Mr. Beck. Mr. Beck asserted that the publisher had amended his original manuscript without his consent. The manuscript was disclosed in 2013 and put Mr. Beck in the lead up to his election to Bundestag. Mr. Beck showed the text to the press to demonstrate that it has been altered, but he did not give consent to its publication. Mr. Beck also published the manuscript and article on his own website accompanied by a statement disassociating himself from contributing and stated that original publication articles were unauthorized. Spiegel then published an article that asserted that publisher had not altered the original article. Spiegel made the original version of manuscript and the article available via hyperlink. At first instance, Mr. Beck succeeded in claim for the copyright infringement. However, on appeal of German appeal court referred in question to TFEU, is concerned the interpretation, reception, limitations, copyright, and the relation with fundamental right. So, and then as we have discussed so far, they have raised you 6 questions. But the most important thing is, firstly, the balancing fundamental freedom with application of copyright. So, the answer to question 1 to 3 generally are just helpful revision on how member states can apply and interpret copyright law having regard to fundamental freedom. The judgment make clear that although any publication on a general rules should be consistent with the fundamental freedom, it cannot alter or expand the wording of directive itself, and such analysis should already be inherent in the application of the right limitations set out in the directive. There has been a recent trend to refer to the fundamental freedom as part of analysis to the application of copyright law. The decision may assist to prevent the growth of this. It prevents freedom of expression and freedom of press being used to justify any attempt to attend the scope of exception and limitation to the right of the author. Therefore, this should strengthen the rights of the author. So, they will protect more the rights of the author. The second problem is about the consent of the right holder and lawful available. It is thankful that the GJU reached the view that the exception and limitation are not preclude where the consent of the right holder is not sought, since this is precisely the purpose having such exception limitation. In respect of the seat question, the answer effectively repeated by directive and left it as a matter for national court to determine. Therefore, this question do not add much to the existing law. And lastly, about the definition of quotation. The conclusion that a hyperlink is covered by Article 5 is far from controversial. Of far more interest in this question was the additional commentary provided by the GJU generally on the scope of meaning of quotation, which is particular interest in the UK given that the way in which our legislature had implemented exception and limitation in the directive in Section 30 of the Copyright Design Patent Act 1988. Section 30 permits use of quotation from a work provided the standard fair dealing criteria is satisfied and that the standard quotation is no more than is required by the specific purpose for which it is used. Even absent to particular purpose in subsection, the exception has been seen by many commentators as effectively allow a broad fair use defense by the back door. It allows the user to consider their own purpose on how this can be satisfied, rather than fit within one of the other statutory purposes, such as criticism and review, research, caricature, parody, or pastiche. Therefore, this guidance on the interpretation of quotation is helpful to understand the scope of this exception under CDPA. All right, so that's the case for today. And this case have opened up many things to discuss. And I hope you can have very good article to understand. Nguyễn Thái Cường report from Institute of Intellectual Property and Competition, 7 October 2021. Thank you.